Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering the woke shutdown as a judge humiliates a race-based investment company, preventing them from discriminating against the people they give investments to based on race. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. I've been keeping an eye on this story, and it looks like it's starting to work out well. From the Washington Post, a federal court, this is the appeals court, is halting a private grant program for black female entrepreneurs, but black female entrepreneurs only, which means you're excluded from this if you don't happen to be of a certain race. In issuing an injunction, the appellate panel wrote that the Fearless Fund's racially exclusionary program might violate a federal anti-discrimination law. They would not be granting any kind of injunction preventing the fund from continuing with their grant program unless they were confident the program is illegal. A panel of federal appellate judges on Saturday temporarily blocked an Atlanta-based venture fund from awarding $20,000 grants to black female entrepreneurs, writing that the program was, quote, racially exclusionary and substantially likely to violate federal law prohibiting racial discrimination in contracting. The temporary injunction issued by a panel on the U.S. Court of Appeals for the 11th Circuit prevents the private Fearless Fund from closing its application window. The fund was sued this summer by a conservative group alleging that its program discriminated on the basis of race by exclusively handing out grants to black female business owners. Saturday's decision reverses a Tuesday ruling by U.S. District Judge Thomas Thrash, who denied a request by the plaintiff, the American Alliance for Equal Rights, to halt the grant process. The alliance, led by conservative superstar Edward Blum, filed its lawsuit in August, a month after the U.S. Supreme Court effectively banned race-conscious or race-based college admissions through rulings on cases that Blum himself initiated against Harvard and the University of North Carolina. Edward Blum has been fighting against affirmative action and for fairness for employees, for college students, for businesses, for everyone for decades now. And his most recent win before this was the U.S. Supreme Court's getting rid of affirmative action in college admissions. And he's not done. Quote, the members of the American Alliance for Equal Rights are gratified that the 11th Circuit has recognized the likelihood that the Fearless Strivers Grant Contest is illegal, Blum said. We look forward to the final resolution of this lawsuit. A separate 11th Circuit panel will now decide whether the Fearless Fund will be blocked from awarding money under its Fearless Strivers Grant Contest while the case is litigated in district court. Saturday's order merely halts the grant process until that separate panel issues its ruling. It's unclear when that determination will be made. Quote, we respectfully disagree with the decision, appreciate the important points made by the dissent, and look forward to further appellate review, said Jason Schwartz, a lawyer with Gibson, Dunn & Crutcher, which is representing the Fearless Fund. Quote, we remain committed to defending our clients' meaningful work. Thrash, who was appointed by President Bill Clinton, denied the Blum-led alliance's preliminary injunction request last Tuesday, ruling from the bench that the Fearless Fund's grant program qualified as charitable giving, a form of protected speech under the First Amendment. The alliance appealed hours later. But in Saturday's order, a majority of the 3-judge appeals panel held that the First Amendment does not protect the Fearless Fund from awarding grants only to black women. Judges Robert Luck and Andrew Brasher, who were both appointed by Trump, concluded that the plaintiffs established that the Fearless Fund was substantially likely to violate the law if they closed the application window and awarded the grants. In the dissent, Charles Wilson wrote that he would deny the injunction, arguing that the alliance did not meet the requirements. Wilson criticized plaintiff's citation of the Civil Rights Act of 1866, a Reconstruction-era law meant to grant economic rights to enslaved people who were emancipated. Quote, it's a perversion of congressional intent to use the law against the remedial program whose purpose is to bridge the gap in venture capital funding for women of color founders, a gap that is the result of centuries of intentional racial discrimination, Wilson wrote. But the problem is the laws don't just apply to one or one another race. The entire purpose of laws is so that everyone has their rights respected and protected by society or the government. And if you feel like your rights are being violated, why shouldn't you be able to go to the government and say, hey, look, I feel like my rights are being violated. Here's the law I think they're breaking. Can I get some judgment on this? And that's what's going forward. In addition to the Fearless Fund case, the Blum-led alliance in August sued two law firms, Perkins Coie and Morrison & Forrester, alleging that the firm's diversity fellowships for law students discriminated on the basis of race, which of course they discriminated on the basis of race. It was open only to certain races. You can't do that. And the idea that you're going to try and right the wrongs of history by discriminating against people today, it just doesn't work. And it's a little bit difficult to trust that everyone's intentions are so good, so don't worry if we violate the law. I don't really trust people who want to violate the law because they think they're going to go and change history. No one can change history. We have to learn from it and move on. A little bit more background on the Fearless Fund, because they're more than just a grant program. They're actually an investment group that focuses on investments only for women of color. From Fortune, the Fearless Fund founders are sticking to their investing philosophy and have some strong words for the conservative activist groups suing them. Well, the strong words are, you're losing so far. And of course, this was from before the recent ruling. Co-founders and general partners of Fearless Fund, Arian Simone and Ayanna Parsons, are being sued for racial discrimination by a group founded by conservative activist Edward Blum. Their message to reporters, quote, activism is in our DNA, Simone, who is also CEO, told The Room. We are not scared. We are fearless. See, like the name of their business, Fearless Fund. But you need to be a little fearful if you're going to break the law because you're going to get in trouble. Just a couple of weeks ago, the 4-year-old firm, whose first fund was $25.8 million, was still somewhat under the radar, writing small checks of up to $2.5 million and in the process of raising fresh capital amid the rocky venture environment. The firm has raised $16 million so far for its second fund, according to a May SEC filing. As far as numbers go, these are very small numbers. It's a little surprising to see them raise such little money, considering they're obviously very well connected and they're pushing a social agenda. Now the early stage Fearless Fund has been thrust into the national spotlight as one of the faces defending diversity-focused investing, backed by a team of big-time lawyers. And they're at the center of what could be a major story in the venture world right now, one that could have major ramifications for the industry at large. Because, of course, there are people in every industry that want to look to see, well, can we discriminate? Can we get away with it legally? The answer is basically no, you cannot. You're not going to get away with it. Fearless Fund has heavy-hitting lawyers in their corner. Ben Crump, an attorney known for representing the families of George Floyd and Breonna Taylor, and Janai Nelson from the NAACP Legal Defense and Education Fund are among those representing the firm. Fearless Fund highlighted in their response to the lawsuit, the recent ruling rejecting affirmative action in higher education, quote, has become a catalyst for more legal groups to attack critical investments in marginalized communities, the firm wrote in a release prior to the press conference. But some insiders also worry about what the lawsuit might do to limited partners investing in these types of funds. Quote, if this lawsuit successfully deters limited partners from supporting funds with racial mandates, especially in a further deteriorated fundraising environment, it will be hard for these funds to grow beyond Fund 1 or Fund 2, which replenish sources of capital for entrepreneurs. According to Yasmin Farine, a co-founder and general partner at Visible Hands, a venture capital firm that has accelerators for underrepresented founders, wrote in a blog post this week. In a follow-up, she also said that these minority-focused venture capital firms are still relatively young. They haven't had sufficient time to prove their returns to limited partners or pre-seed and seed companies, which is to say that these funds, while people like to use these funds for virtue signaling and to push woke agendas, they don't actually result in returns on investment. And she follows up saying, quote, I worry that just giving as an out of justifiable legal liability for limited partners will reverberate. And what she means is, yeah, you're going to get sued if you're going to support funds that discriminate against races, no matter what those races are. And if you're not going to return money to investors at a profit, then why are they investing in you in the first place? Just to get sued? So far, big corporate backers of Fearless Fund, including Bank of America and JP Morgan Chase, are rallying around the firm, co-founder Simone said on CBS Mornings earlier on Thursday, adding that, quote, they stand by their DEI programs. It's too soon to tell how this will play out or how the fund's lawyers will go about their defense. Fearless Fund's legal counsel would not answer questions about their strategy during the press conference. Of course, because you've got Benjamin Crump, who is a publicity lawyer. But this will be a precedent-setting case that venture capital firms should be paying attention to. Okay, so good news on the Fearless Fund. It looks like they're in trouble and they have no defense other than to say, we love diversity, equity, and inclusion, and we want to fund whoever we want to fund, and we don't care if we discriminate. Well, now they're up against Edward Blum, who got affirmative action pulled out of all colleges. He's extremely effective, and if he's targeting you, you need to stop the racial discrimination, or he's going to have judges do it for you. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up, and I'll see you again soon with another video. And if I don't see you, I will miss you.